Roberto Klein versus Yanez. You may proceed.
Please, the court. My name is Joel Perwin, here with trial counsel Phil Frieden for the plaintiff, Mr. Klein. As this case has evolved, there are, at least in my opinion, three issues which are either conceded or not contested, and they form the predicate for our argument. One of them is that there was an issue of concurring causation in this case. The most the defendant can say in response is that it wasn't the main issue, it was a minor issue, it was a secondary issue, all of which may be true, but there is never a denial that there was, in fact, an issue of concurrent causation in which the doctor, even if he couldn't have prevented the entire extent of the injury, could have prevented part of it. And the issues supporting that, all of which are ignored in the answer brief, are at pages 7 to 12 of our brief. We can contrast that, as I get to it, to some of the cases in which the court held that no concurring causation instruction was necessary because it was essentially an all-or-nothing proposition. Either the doctor would have prevented the entire injury or he was responsible for the entire injury. The paradigm is the Supreme Court decision in Goldschmidt. That's exactly the way a 5th District case called Hadley interpreted Goldschmidt, and a 4th District case called Wilson, which the other side has cited. Point one. Point two, it has now been conceded that the plaintiff did propose in writing the entirety of instruction 5.1b, which includes the concurrent cause instruction as it applies to a pre-existing condition. There was a fight about that. We did not file it in writing, true, but it's conceded that we submitted it in writing and that it covered the entire charge, including what's at issue there. That, therefore, is no longer an issue in this case. Point three, it is conceded by omission, at least, that the general rule, as articulated at pages 15 to 17 of our brief and page 5 of our reply brief, is that if the facts of the case present an issue of concurrent causation, the judge must give such a charge, unless it's harmless, which I'm going to talk about, but on the merits, the judge must give such a charge, and it is harmful error, as a presumptive matter, not to give it, because every litigant has a right to have the jury charged on a theory presented by the evidence. It's now conceded that at least a secondary theory was presented by the evidence. That leaves two questions. One, was it harmless error to decline to give the charge? And two, is the issue preserved for appeal? On the question of harmless error, we have cited a series of cases at pages 15 to 17 of our brief, which says it is presumptively harmless error unless the other side shows otherwise. Two, we argued that in this particular case it was especially harmful because there were two theories of concurrent causation in this case. There was the pre-existing condition, and there was the asserted concurrent causation of other health care providers. And the asserted contribution of those other health care providers was covered, the trial court held, and I cannot disagree, by the standard Fabre charge, which said you could allocate comparative fault to other human actors, to other asserted wrongdoers. That charge was given. And therefore, I can't argue that it was a harmful error as opposed to not give it, as opposed to the Fabre, because as the court said, we've covered it in other ways. There's a case called Gallagher out of the 3rd District, which the other side cited, which is a paradigm of that, in which all the other asserted concurrent causations were human beings, human health care providers. The court said that the substitution of a Fabre-type charge rendered that harmless, even if the charge was required. Here, however, we have a pre-existing natural condition, a disease, which assertedly joined with the asserted negligence to produce the harm. And I would submit that it was particularly prejudicial for the trial court not to give the concurrent causation charge supported by the evidence of that disease when the court was telling the jury that you can apportion fault if the other cause is human wrongdoing, which at least created a negative inference that you can blame the pre-existing natural cause for the entire accident and let the doctor off the hook. So I think that there has been no rebuttal of the presumptive prejudice which occurs if there is a failure to give a charge supported by the evidence. That leaves one issue, and it's about 80% of the other side's brief. It was also a basis for the court's holding, and that is that the point was not preserved for appellate review. And here's what happened. We submitted the charge. There was a very, very small and brief discussion of that charge at the charge conference. And it's quoted at page 4 of my brief. Assertedly, according to the other side, the court perceived the request for the charge to apply only to the Fabre situation. I asked the court to read it. There is nothing in that language which in any way implies that. The court says, well, you have 5.1b, it's confusing, I don't think it applies, you need a but-for charge, then you argue that all of this other negligence contributes, but I don't think 5.1 applies. Very quickly, and then the court moves on. It was a very truncated discussion. Now, the key to the waiver question here is that we did not posit at that charge conference, in the brief time we were permitted, that the only reason we sought that charge was because of human concurrent wrong. We didn't give a reason at all. We said we think we need the charge. We said we think it's supported by the evidence. The judge dismissed us, said, I don't think it's appropriate, move on. I submit that our asserted failure to specify the reason which I'm advancing on appeal was not a waiver. Sure, there can be a waiver in such a circumstance. If there are two bases for a charge, and I say, Judge, I only want it for this reason, of course they could argue that I've waived the other reason. But we didn't give a reason here. We weren't given the opportunity to give a reason, and therefore, we submit that the issue is preserved. We have cited, in the original citations at pages 7 to 12, a plethora of cases, including cases from this court, holding that if the evidence creates an issue of concurrent causation, the court must give the charge.
Let me ask you a question. If the evidence is there still has to be a request for an instruction, am I correct?
Yes, Your Honor.
And the request for the instruction here was a blanket request, or the form?
Yes, Your Honor.
5.1 A, B, and C.
Yes.
But the brackets, particularly in B, all the brackets were in there when they were given to the judge.
Correct.
Okay, and so your position is that even with the brackets in there where you have two different legal issues, that the judge was still wrong in not presenting it, even though it wasn't specified for the judge which one it was supposed to be?
Yes, Your Honor, because we did not omit a bracket. So we were submitting the charge in its entirety, and we made no affirmative statement which said we only want this and want this, or we want it for only this reason or this reason. The judge did say at one point, we don't know what charge you provided because you didn't file it. We now have an express concession in the answer brief that we submitted in writing. We didn't file it. I know we didn't file it, but we submitted in writing the entire charge with all the brackets in it.
All right,
So
well, counsel, your time is about up. Do you want to save some time for rebuttal?
Yes, Your Honor. Thank you.
Okay, are you basically concluded with this section of your presentation?
I was going to say two quick things, and I guess I'll take my chances. One, the court said that, well, only one thing. The court said, no, two things. The court said you didn't also combine your concurrent causation charge with an aggravation charge. There's no authority that says you have to do that. We cited a number of cases which say if you're entitled to a concurrent cause, you get it. You don't have to propose another charge, whether it may or may not be appropriate. Two, the court said, well, it's harmless under the two-issue rule, because the jury could have found no negligence, and therefore any error in instructing on concurrent causation was harmless. We cited a plethora of recent Supreme Court decisions which says the two-issue rule does not apply to sub-elements of a cause of action. It only applies to two causes of action. When you have the issues of negligence and causation in the same jury instruction, the two-issue rule works in my favor. It cannot be assumed that there was no error on another basis for discovery, even if there was error on ours. We win the two-issue rule argument. There was prejudice. There was error. The judgment should be reversed.
We'll give you about a minute for rebuttal, counsel. Welcome.
May it please the Court. Brett Powell for the appellee, Dr. Gonzalo Yanez. The final judgment pursuant to the jury verdict should be affirmed in this case for three reasons. First, the appellant has failed to present an adequate record on appeal and has waived the right to challenge the court's decision. Second, the trial court was within her sound discretion in refusing the instruction as requested. And third, in the alternative, even if there was error here, that error was harmless. Looking first at the waiver issue, because I think this is crucial. First of all, the record is unequivocal that the appellant has conceded they did not raise the pre-existing condition as a basis for their request. The charge conference in this case comprises over 50 pages of trial transcript and reveals a considerable degree of give and take between the attorneys and the court. Yet on this issue, the colloquy is very short, and the court says, quote, "You have 5.1b. It's so confusing when you have comparative fault. I just don't think it applies. I think what you need is the but for, and then you can argue all this other negligence contributes. I don't think 5.1b or c, which of course is the intervening cause instruction, applies." To this, the trial counsel simply responded, "We're requesting it, but we're requesting 5.1b and c." The court then states, "I'm not going to give it because I think it's confusing when you have comparative issues." Just note our objection, Judge. Later, the trial court invited counsel to correct any supposed misunderstanding before the jury was dismissed to deliberate the jury verdict, and the appellant passed at that opportunity as well. Now he stands here and argues that he was never given an opportunity to articulate a basis for his request, and that the basis of the trial court's decision caught him totally by surprise. He had no idea that she believed they were requesting this solely on comparative negligence grounds. In addition, as the appellant has admitted, they failed to file this written request as is required by the Florida Rules of Civil Procedure, which state not later than the close of the evidence the parties shall file, not submit, not propose, shall file a written request, and that the failure to do so constitutes a waiver of the court's decision on appeal. He maintains that the request was properly submitted to the judge. There is no evidence to that effect. The record does not reveal that. In fact, if anything, the record demonstrates that the opposite is true. The court said again, "You have 5.1b. It's so confusing when you have comparative fault. I think what you need is the but for, and then you can argue the other negligence contributes. I'm not going to give it because I think it's confusing when you have comparative issues." Assuming, as the appellant argues, that the court was actually looking at the requested instruction at the time, which we don't know for a fact because it wasn't filed, the obvious implication here is that the bracketed language regarding the pre-existing injury was not presented to the trial court. She's not looking at this saying, "Well, I see you have written pre-existing cause." She's saying, "I see you have comparative fault," the comparative issues here. The record certainly does not support the appellant's contention. Now, faced with that very obvious truth, the appellant, frankly, is making a ridiculous misrepresentation here, stating that he uses the word conceded here. In his reply brief, he says that we stipulated the fact to, quote, "a verbatim in writing with no omissions," end quote, version of this instruction. We've done no such thing. As we noted in our answer brief, the plaintiff's assertions are unsupported by the record, and we specifically stated that we cannot confirm nor deny whatever was written in the submitted written instructions, because there is no record of it. We don't have any independent knowledge of it, and there's nothing in the record to indicate what was in that written instruction, although I think if you look back at the trial transcript, it appears that the opposite is true. Second, the trial court statement at the charge conference. We cited this as evidence of the fact that the trial court believed that only the comparative negligence issues were being presented. We cited the trial court's invitation to correct any perceived misunderstanding or any supposed misunderstanding on behalf of the trial court, which the appellants did not take advantage of. We cited the fact that the trial court gave both parties the opportunity to supplement the record at the hearing on new trial when she specifically requested supplemental memoranda on the waiver issue. The appellants did not submit the record at that time. Now, here at oral argument and in their reply brief, they actually argue that they've had insufficient opportunity to supplement the record and demonstrate the assertions that they're making. At this point, it's too late. Unless their position is that they demand the right to supplement unless we acquiesce to the misrepresentation. We've not conceded this point. We have not, certainly have not made any stipulations on this point. It has always been our contention that they have waived this issue on appeal. And that brings us to the next point. The trial court can't be held in error for failing to give an instruction that was never requested of it. Because the record there's nothing in the record to demonstrate that this request was ever actually given. The trial court can't be held to be in error for not giving that instruction. In addition, the court's given broad discretion based upon the trial court's view of the evidence, the progress of the case, what the trial court perceives to be particularly important or not important, when deciding what instructions are required to be given. That discretion is included in the directions regarding the instructions and has been acknowledged by the Florida Supreme Court in Goldschmidt versus Holman. In the case of Wilson versus Boca Raton Community Hospital, a procedurally similar case, there the issue was a decedent died of paraquat poisoning. The defendant doctor was charged with negligence and failing to timely diagnose the poisoning. He defended on 3 grounds. 1, that he was not negligent. 2, that the death was the result of the negligence of others. And 3, that the die was cast, that this gentleman was going to die of the paraquat poisoning no matter what he did, and therefore the causation element was negated. In this case, the issue was whether or not Dr. Yanez timely responded to a consultation call, which they claimed was sent stat. We maintained was always delivered to Dr. Yanez as a routine call, and so the question was who dropped the ball, who didn't get the message to Dr. Yanez. But he defended on 3 grounds. 1, he wasn't negligent because he acted properly in responding to what he received as a routine call. 2, the negligence of others in failing to get that message to him properly was the cause of the injury. And 3rd, the die was cast, that Mr. Klein's injuries were going to result in his paralysis no matter what. Here, as in Wilson, the gravamen of the case was whether or not the doctor was negligent. And as in Wilson, it is not reversible error. There is not error at all to refuse that instruction based upon the trial court's assessment of the evidence. Finally, if I can just point to the harmless error issue. Before the jury's verdict can be overturned, the appellant has to demonstrate 2 things. First, that the jury was confused by the failure to give the instruction, and secondly, that this confusion results in a miscarriage of justice. In Gallagher versus Federal Insurance Company, which the appellant alluded to, this quote said that reversal is justified only where, quote, the court finds from the record on appeal that the jury was misled. A verdict will not be set aside simply because the court failed to give instructions which could have properly been given. Reversal of a judgment is justified only where the record indicates that the jury was misled by the failure to give the instruction. There is absolutely nothing in this record to indicate that the jury was confused. The appellant relies on Cruz versus Placencia, in which this court found that it was reversible error to not give this instruction. That case is distinguishable from the present and demonstrates why this case there is no harmful error. This court specifically premised its decision based on affirmative showing in the record that the jury was confused by the failure to give the instruction. There, the trial court had allowed closing arguments before holding the charge conference, which is error in its own right. The counsel referred to the concurrent cause instruction during closing arguments, but then the judge refused to give the instruction. The jury sent questions out to the judge asking about the very issue contained in the concurrent cause instruction, and over repeated requests of the trial court, or the trial counsel, the court refused to give the instruction. This court held that the record evidence demonstrating that the jury was confused in the form of the questions sent to the judge demonstrated that the jury was confused. There's no record of anything like that in this case.
All right, well, your time is about up. Counsel, if you could draw your argument to a close, please.
Yes, Your Honor. Very briefly, the appellant waived every opportunity to articulate a basis for the instruction. The counsel waived every opportunity to clear up any supposed misunderstandings. The appellant has failed to supplement the record at this point and can't do so at this late date. And because of those failures, he's left with absolutely nothing in the record to indicate what the instruction was, and there is nothing in the record to indicate that the jury was in any way confused. The court has the broad discretion to refuse the instruction based on the court's understanding of the evidence, and therefore the trial court was correct in refusing the new trial. This court should not overturn the jury's verdict in this case. Thank you.
Rebuttal.
May it please the court. 1, answer brief at 4. The plaintiffs, quote, did make a blanket request for standard jury instructions 5.1a through 5.1c. That includes B, regarding legal cause, concurring cause, and intervening cause, close quote. If that's not a concession that we propose to charge, I don't know what is. 2, 2, it is not necessary to repeat your objection after the charge is read unless the judge read the charge incorrectly. The cases are at our reply brief, page 6, footnote 9. You don't have to renew an objection if it's preserved. We made the objection. 3, there is nothing in the language of the court's comments which connotes the belief which she stated later that she was only referring it to the concurrent negligence of individuals as opposed to a pre-existing condition. We never focused on that. We weren't given the chance. Number 4, counsel's statement that the, quote, gravamen of the case was something else does not, as we established, obviate the need for an instruction on another issue which was presented by the evidence. I don't care what the gravamen of the case was. There was an issue here. We were entitled to the instruction. 5, and then I'm finished. Harmlessness. It is not our burden to show affirmatively that the jury is confused. Yes, in Cruz, the jury sent in a note. Does that mean that you only win this argument when the jury says it sends in a note and says we're confused? If you adopt that doctrine, this theory, this basis, this long-standing rule doesn't exist. There aren't that many cases in which the jury sends in a note. The general rule, we cited the cases, if the evidence supports the charge, unless there is affirmative evidence that the jury was not confused, then there is prejudice. The Gallagher case, the court did say that. But in the Gallagher case, the court said there was no evidentiary basis for the charge in the first place. And therefore, unless you show me the jury was confused, you weren't entitled to it. Gallagher was an all-or-nothing proposition. It is conceded here that we had an intermediate question of concurrent causation. It justified the charge. The charge was requested. It was requested in writing. It covered pre-existing conditions as they conceded, and we were entitled to it. We were severely prejudiced. There was an instruction on human beings' concurrent evidence, leaving a gaping gap in the question of pre-existing disease as a factor, suggesting prejudice, I would submit, and the judgment should be reversed and remanded for a new trial.